To order. Before we proceed with this evening's agenda, we ask that you please rise and join us in saluting the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Chair recognizes Planner Matthew Collado for reading of the items that are to be recessed this evening.
Good evening, Mr. Chairman and members of the Planning Board. The Planning Department would like to recommend the following items be recessed because the applicants are not ready to be heard at this time. Under zoning petitions, number 1, 2012-04, Storybook Homes, Nesconset. Number 2, 2012-02, Carlson Associates, Kings Park. Number 3, 2010-06, KVC Holdings. Under waiver requests, 4, number 773, Scholar Estates, Comac. Number 5, number 1135, Tuami Platte, St. James. Number 6, 911A, Glen Hill Northern, St. James. And under amendment of conditional approval, it's a 288 application, second map of San Remo.
Is there anyone present here this evening who wishes to be heard on any of the matters recommended to be recessed? There being none, is there a motion?
Motion to recess items 1 through 7 as read.
Second.
All those in favor?
Aye.
Opposed? Motion carries. The items are recessed. On the next item on the agenda is under new hearings and decisions. We have a preliminary subdivision for Foxwoods Estates off of Landing Avenue in Smithtown.
The memo is the same one that was read into the record last meeting.
Okay.
So,
Mr. Tramarko, you're present on behalf of the applicant.
I am Vincent J. Tramarko, 1038 West Jericho Turnpike, Smithtown, New York. I believe at the last meeting, one or more of the members wanted to view the subdivision. I suspect that you have, and ask the board for a favorable approval of the preliminary map.
All right. Any members have any questions or comments of Mr. Tramarko? Any me-
Just one quick question. The existing house that's here, I mean, that house is not being taken down, it's
No.
staying where it is? Okay.
Any members of the public wish to be heard on this matter? Okay, I just have several comments. I was at the site today, and I noticed there's a slope down towards Burham Drive. Now, I've known over the years several residents on Burham Court, and they've complained of flooding. How would clearing this property exacerbate that condition that these residents complain of? Because the property does slope downward from behind where the 3 houses are going to be in the backyard of the existing home.
Right. Certainly, any clearing does allow more water runoff. However, as you well know, the engineering department is going to approve the drainage facilities on the property to retain all the water within the subdivision. Part of the rules of subdivision regulations are each subdivision must retain its own water, just as any house that's built must retain its own water on the property. So it's a pretty good bet that the Town of Smithtown Engineering Department is going to make sure that the water doesn't flow to the other subdivision. Probably better now with the improvements being proposed to be done than it is, with just woods there.
Okay, I just question the fact, because once you clear things, that would increase runoff. My only other problem is, the house, or what would be Lot 1, you have a road or a roadway going next door to the house, or between that and the adjacent house, and then literally putting 3 houses in back of the one on Landing Avenue. I don't know, I was there today, and I observed, a great deal of heavy traffic, and where this roadway would come out is at the base of a hill, which is to the north, and I would really question the safety for residents, entering and exiting that roadway as proposed.
I believe traffic safety as part of the subdivision process and application had looked at the project and approved that ingress and egress for the road. There was a comment, I believe, by the planning department to eliminate the access on Landing Avenue for the existing house. We just as soon keep that access, and it'll be one less group of cars coming off the property if the existing house maintained its present access.
Okay.
Apparently, planning feels that it would be better to have everyone come off the new road. But as I say, it would be fine if you allowed them to keep the present access and no access on the private road for the existing house.
Okay. Any other questions, comments?
This is the one where,
Yes,
then the driveway is gonna go right next to the utility pole?
yes, I believe so, on this photograph.
I don't know which one.
That would be the road, it wouldn't be the driveway, right?
Actually, a roadway.
Yeah, the Foxwood Court.
It'll be common,
Right,
Right.
Existing road,
Right.
existing driveway, I'm sorry.
okay. Any other questions?
I just had one.
Yes.
On that matter of that recommendation that it is safer to have cars ingress and egress on Foxwood Court rather than Landing Avenue. I was just curious, now that the cars do come and go from that driveway that's existing on Lot 1, I guess would that be safer, would it make a difference if that stayed and the three houses use the other ingress and egress?
That's what I think.
It's just
They maintained, or if the board allowed us to maintain the existing driveway for the existing house, then you would have the cars coming from the three new houses, but not from the existing house. I guess planning felt it was more efficient and safer to remove the driveway on Landing Avenue. But these people have lived there for a number of years, and they've specifically asked me to ask the board if they could keep that driveway and not make an exit onto the new road.
Well, I think you have a situation here where someone, and I'm sure Mr. Flynn will speak for the planning department, but someone might think it's safer to have just one ingress and egress versus two, so close to each other. Maybe that's the thinking behind having only one way in and one way out, but
If I could maybe add to this and make a suggestion, probably for 60 years, it's standard design practice to reduce the number of curb cuts on a main road. Based on empirical information, that the more curb cuts you have, the more accidents you have. Landing Avenue is a main road. The posted speed limit's 30 miles per hour, but I think it's safe to say that it's not adhered to very much.
maybe at all.
Okay. And there, in the past 10 to 20 years, there's been a contrary hypothesis introduced by planners more than engineers that say that the fewer curb cuts you have is actually counterintuitive, because now you're encouraging people to go even faster. The more curb cuts you have on a main road slows people down. I don't know of any source where someone would want to go to court if there were an accident and say that's a sound decision based on advice, based on real data. But my recommendation would be since this is the preliminary plat, maybe change the wording of the condition of approval to say that that shall be eliminated unless there is information that to the board's satisfaction that it's safer to leave the curb cut there.
that would be fine with me. We want to do it whichever way is the safest. And if what you're saying is put off that final decision until we get to the final, because we may have more information and make that
Right.
a better decision, better informed decision, I think that makes sense.
Right. Like I said, this goes back to the 1950s. The standard practice, almost like a reflex, all across the country on arterial roads. Textbooks say reduce the number of curb cuts.
Well, you have less people coming in and out.
Right. Well, it's the same number.
I mean,
but
less
they're-
spots of people
Yeah,
coming in and out.
they're concentrated in points, so the
And it's
driver
also
on the-
metered if you're coming out in small sections rather than everybody dumping out at the same time,
and
if that was the case.
the motorist on the main road has fewer places to look for people coming
People
out.
coming out.
Yeah, or two people don't come out at the same time, 50 feet apart.
Right,
that kind
that's
of thing.
what this situation could
Yeah.
result in. But I don't have any problem with doing it that way and just delaying it or understanding that we're contemplating possibly doing one versus the other, and when the time comes, then the final decision can be made. I think it's a good suggestion as far as I'm concerned. I don't know how
If
everybody else
you
feels.
wish to amend it, I'm not supportive of this application. I think it sets a dangerous precedent that everybody with a large piece of property could put a road next to their house and put 2, 3, 4 houses, depending on the acreage. This is like a flag lot incarnate, and for that reason, I can't support. But if you wish to amend the resolution accordingly, that's your prerogative.
When it comes time for a vote, I guess. That's
How would you want it to be amended? You want to give us some wording, or what section are we specifically be looking at?
It's condition
3.
3. To keep the wording the same, the applicant shall remove the existing curb cut for Lot 1 on Landing Avenue. Access shall, and then I would add a clause in there that says that unless information to the satisfaction of the planning board is received by the time of final plat approval that demonstrates that keeping the access is safer.
All right, so then,
But you gotta be careful with that, because what does that mean in terms of, I mean, you can't, either you make a determination or you don't. I think your point, Dave, really is that they can make that decision at a later date if
That's
somebody
right.
comes forward with new information, but you really can't put that in.
Okay?
It nullifies, it eviscerates the whole point of the condition. I mean, I think you've got a solid condition and a record establishing the basis for it, which is very important.
Mhm.
If new information comes forward at a future date, then that forms the basis for changing it. So I would recommend that, you know, the vote be taken on the basis of the record that's in front of you, and then at a later time, people can bring forward information and you can make the judgment at that point.
So-
is there any reason, without that amendment now, that the board would be prohibited from making the change when we came to the final?
That's a legal question.
If there's a foundation for it, the important thing with all these decisions, these are administrative determinations, you always have to have a record
Yeah,
that
but I'm saying, I
supports
don't
what
think
you're
we would just
doing.
do it willy-nilly.
So you can't make a determination today which basically says, you know, we determine A, except that, you know, some ambiguous, nebulous future event, you know, may undermine it and undercut it as opposed to an affirmative vote. So you make a determination today based on this language, and if information comes forward at a later date before, when you have the hearing on the final approval, that becomes the record on which you make the determination.
And there could be just a different resolution then, if in fact the information supports having the difference that we're talking about now. So that we're not really tying our hands by not putting in this language now as the final.
Exactly.
Okay.
Because it's not the end. We still have one more.
Right.
Okay. It sounds reasonable and logical. Okay.
All right, if there be no further discussion, do we have a motion to close the public hearing?
In the matter of number 1146, map of Foxwood Estates, I move that we adopt the resolution as read.
We gotta close the public
Oh,
hearing
I'm
first,
sorry,
right?
move that we close the public hearing.
Second.
All those in favor?
Aye.
Opposed? Motion carries. Public hearing is closed. We have now before us 2 resolutions, one a recommended secret declaration and a preliminary approval for the subdivision. On the secret resolution, all those in favor, please signify by saying aye. Those opposed, no.
Well, we're voting on whether or not we're going to
Except the
make a
application.
recommendation of the secret
Right.
only.
This is just for the.
Do you want a motion on that first?
Yes.
So with respect to Foxwood Estates number 1146, as to the secret resolution only, I move that we adopt that resolution in accordance with the recommendation of the planning department as to the secret resolution only.
Second.
All those in favor?
Aye.
Opposed? Opposed?
Opposed?
So it's 3-2.
I was opposed
Yes,
also.
okay. So on the
I thought you said aye,
resolution,
no?
the ayes are 2, the nays are 3. The resolution is not adopted. On the resolution for the preliminary subdivision approval,
What was the
can't-
vote?
Approve something without the secret note.
Yeah, I think that makes it, does that make it academic? Because
Well, you can't,
if the secret is not approved, then we really can't go to the second step.
you have to either, table the second resolution or vote on the, merits to defeat it, but you can't adopt it without the secret determination.
right. Okay.
So, it would seem to me if you defeated the secret, you would just table the second resolution.
Table subject to call?
Yeah, you could table it to it, that's a good idea. Yeah.
Okay. Motion to table the planning board resolution for the preliminary subdivision approval for Foxwoods Estates, subject to call. Do I have a second?
Excuse me,
Anyone
Mr. Chairman.
second it?
Yes.
I'll second it.
Second. All those in favor? Aye.
Aye.
Opposed?
Opposed?
Opposed.
And just state for the reasons that I oppose is that I voted in favor of the secret resolution, and I think that both resolutions should be approved, so I'm not in favor of tabling the second resolution, which is why I'm
Okay.
opposed.
Ditto to that.
I just have a question. Your second resolution was to table it subject to what?
Call.
What that means is that it's subject
Yeah, I
to the
wanna know what
ability of
that
the board
means.
to recall it at a future date, as opposed to tabling it to a specific date or to a date uncertain. So it means that it's out there. If for some reason the secret process gets revived on the merits, it's eligible up until the end of the year to be reconsidered.
I'd rather the board vote no. This way I can proceed.
Proceed.
Right now, we're in limbo. I can't,
No, you're not in limbo. You've got a secret determination that's defeated. You don't care, well, I can't tell you what to tell your client, but from the perspective of your client, you don't have secret, which means you can't go to the next stage. From the standpoint of the board has all kinds of options. They could have tabled it to a date certain. They could have defeated it, they could have skipped over it, or they could table it to.
But we couldn't approve it without approving the secret first. So basically, by not approving the secret, we're effectively denying the application.
Well, not on the merits.
Effectively.
Because you never know what's going to happen in the future, but, by implication,
Right.
it's.
Without approving the secret, we would not be able to approve
Exactly,
the
that part's true,
resolution.
yeah.
Well, is there another way around it? Can someone, let's say myself, make a motion to adopt the resolution and to approve the resolution, and can we take a vote about the nays and yays then? Can we also do
Well,
that?
I hate to be technical about this, but just
You have to
from the
be
standpoint
technical.
of future, process and procedure, I mean, the real basic rule is that you should not vote on a resolution on the merits if the prerequisite SEQA resolution has not been affirmatively,
That's what I was saying.
determined. So,
Basically,
just to set the precedent for the future, you don't want to vote on the merits of the bill. The choices are table it, subject to court, which you've already done, which is a very effective mechanism. We used it in the county all the time, and it keeps the bill out there, in suspended animation, depending on what happens with SEQA. Or the alternative is you could table it to a date certain, then it's going to carry over on your calendar, whatever that date certain is. So it's your choice, but I would recommend not voting on the merits, so you don't set the precedent that votes can be taken without a SEQA determination in place.
yeah, I don't think we can do that. If we vote secret down, the secret negative, then we really can't go to the second step.
I mean, what happens to the applicant? The applicant is then out there in limbo somewhere forever.
Well, I don't know about that. That's up to the applicant
Folks,
to
From your
address.
perspective, you're the board,
Right.
okay?
The
And
applicant
you've made
may
a
decide to come
determination.
back with a more
It speaks-
viable
The determination speaks
proposal.
for itself. The attorney has to advise his client.
He has
accordingly. It's
options
not
that
for
are
you
available to him, and I'm sure he'll advise to his client what those options are. not for us to tell them what they are.
Right.
We voted, I voted in favor of the secret, but it was voted down. As far as I'm concerned, procedurally, that's it.
The board has acted properly, from a procedural and administrative standpoint. There's no need for you to,
So why would we want to go any further than that?
well, I don't think you should.
Right,
That's
we're
what I'm
good.
saying.
I think-
3-2,
where you are right now,
right.
table subject to call
I
is a
think
good
once the
place to be.
secret is voted down, we really can't approve the rest, so it really doesn't, it's academic, really. To me, anyway.
All right, shall we proceed to the next item on the agenda? Waiver request for South Lake Estates.
The applicant requests to remove the 30-foot limited access and planning easement for lot number 6, Suffolk County Tax Map number 800-107-4-3.6, within the subdivision known as number 948 map of South Lake Estates. This 15-lot subdivision received conditional final approval from the planning board on September 2nd, 1998. The map was filed with a 30-foot limited access and planning easement along New York State Route 347 on lots 3 through 7 and 10 through 12. Additionally, condition U of final approval stated a declaration of covenants and restrictions shall be filed in the office of the Suffolk County Clerk stating that within the limited access and planning easement areas, the following activities are prohibited: vehicular ingress and egress, removal of buffering trees and shrubs, except for hazardous trees, and structures except for the required fence. The applicant is requesting to remove the 30-foot limited access and planning easement on Lot 6. The engineering and highway departments have reviewed the request and have no objection. The traffic safety department has no comment. As part of the recent right-of-way improvements along New York State Route 347, New York State Department of Transportation erected a sound barrier wall along the rear property lines of the subdivision, including lot number 6. This wall prohibits access to New York State Route 347 from these lots and screens the properties from the highway. Thereby, it eliminates the need for a limited access and planning easement. For these reasons, the planning department has no objection to remove the easement from the map. It should be noted that in addition to modifying the map, the applicant will also need to eliminate the covenant on the property. The planning department offers the following resolution for the board's consideration: Planning Board Resolution number blank 2017. Waiver request for number 948 map of the South Lake Estates. Whereas the planning board has considered the request of Joseph and Cynthia Schiraldi to remove the limited access and planning easement on Lot 6 within the subdivision known as number 948 map of South Lake Estates. Now therefore be it first resolved that the planning board hereby amends the map of number 948 map of South Lake Estates so as to eliminate the limited access and planning easement on Lot 6 for the reasons described in the planning department's memorandum dated September 29th, 2017.
Is that the map right there?
You don't have it with you, right?
No.
It's not in the packet.
No, it was in the other one. I just want to see it real quick.
It's number lot 6, it's the shortest lot.
Is there anyone present representing on behalf of the applicant? Please come forward, state your name and address for the record, please.
My name is Joseph Schiraldi.
You have the affidavit of posting?
Yes.
Thank you.
Can you spell your last name, sir? Schiraldi.
Okay, have you heard the recommendation of the
Yes, I have.
planning department? Are you in agreement?
Yep.
Basically, you have a wall in the back of your house, you feel there's no need for the easement,
No, the
it's
wall,
been negated.
yeah.
Okay.
Yeah, the town fence is all falling apart. My wife and I want us to make it so it goes right to the wall. We
Okay,
have 4 kids, we want to use the property for our backyard, so kids have more of a fun place to play, so.
okay, certainly reasonable. Any members of the board have any questions?
Was the easement removed for the other lots, or just applying?
We have the smallest piece of property where we live.
Yeah, I see that, because you cut it.
Most
from the
of our
cul-de-sac.
neighbors have huge backyards. My wife and I basically look at the fence, then we look right at the wall.
Right.
So
No, I can
when we
understand the
went to
issue.
the
I was just
take
kind
the
of
wall
curious if
down?
the other lots also had it removed.
none
No.
of them did.
Okay. All right, no questions.
Any members of the public wish to be heard on this matter? There being no public comments, did you have a question?
No,
No? Okay.
just a motion.
Then Please proceed.
In the matter of number 948, map of South Lake Estates, I move that we close the public hearing.
Second.
All those in favor?
Aye.
Opposed? Motion carries. Public hearing is closed. And on the resolution itself,
In the matter of number 948, map of South Lake Estates, I move that we adopt the resolution as read in accordance with the recommendation of the planning department.
Second.
all those in favor?
Aye.
Opposed? The motion carries. The resolution is adopted.
Thank you very much.
You're welcome. Next item on the agenda is Maria Homestead, a three-lot subdivision.
The applicant requests to waive 4 street trees on Lot 1 within the subdivision known as number 1089, map of Maria's Homestead. This 3-lot subdivision received conditional final approval from the planning board on October 15th, 2014. All 3 lots front New York State Route 25A. The applicant was bonded for 8 street trees. Condition J, final approval required all 8 street trees to be planted at a setback of 5 feet from the state right-of-way. The planning department met with the applicant on April 7th, 2017 to mark out 8 street trees as required by the performance bond. We concluded that 6 new trees needed to be installed and 2 existing healthy trees could substitute as street trees. 4 of the street trees were to be planted on Lot 1. The applicant is requesting to waive these 4 street trees due to the fact that there is a 10 to 12 foot tall hedge approximately 85 feet long, located just east of the front property line. The engineering and highway departments have no objection to the request. The traffic safety department has no comment. The planning department objects to the waiver on the grounds that while the existing hedge provides many of the benefits of street trees, it does not provide shade for passersby. Additionally, there appears to be adequate space to plant the required trees in the designated location. The planning department offers the following resolution for the board's consideration. Planning Board Resolution number blank 2017, street tree waiver request for number 1089, map of Maria's Homestead. Whereas the Planning Board has considered the request of Carmine Sejaci to waive 4 street trees on Lot 1 within the subdivision known as number 1089, map of Maria's Homestead. Now therefore be it first resolved that the Planning Board hereby denies the request of Carmine Sejaci to waive 4 street trees on Lot 1 within the subdivision known as number 1089, map of Maria's Homestead for the following reasons. A, while the existing hedge provides many of the benefits of street trees, it does not provide shade for passerbys. And B, there appears to be adequate space to plant the required trees 5 feet west of the front property line.
I hope I do better on this one than the last one. I'm going to submit to the board, I have 2 pictures of the hedges that are in front of that parcel. As you can see, they're pretty dense. I don't know where we could plant 4 street trees in addition to what you have there. Now, if the board wants, we'll have to chop down some of the hedges and plant the trees. I don't get it. I don't know why the planning department has taken that position. Just a lot of work for no reason.
So, as I understand it, the trees would be planted behind this hedge to shade passersby.
Who's going to see them? The people
Not gonna look
that
too
live
good.
in the house? I mean, it doesn't make sense.
Because you have to take the hedge down.
Those hedges are at least, what, 7 feet? 20 feet? 12 feet.
It looks like there's some type of tree growing behind this one hedge here. I don't, what portion of the hedge.
The street trees that are required, what are those? Typically 20, I mean, that would,
At the time,
Mature at?
at the time, they mature at like 50 to 75 feet.
Okay.
The time of planting, they're 10 to 14 feet tall.
so even at the planted ones would be taller than the hedge.
Correct.
Now,
It's on North Country Road.
it's on North Country Road, and I'm just thinking of if there'd be, would the trees be shaded by this hedge? I'm trying to get my directions. I think the house is to the west of the,
It's on the west side of 25A.
Right on 25.
So is this the person who's living there, who lives in that house there, who wishes to have a hedge in front of his or her house as opposed to 4 trees?
Well, the hedges were there for many years.
Well, I'm saying, but the person who's living there, if we're gonna require these trees to be put in, that spot is where the hedge is now, correct?
Yeah, well, the planning is saying plant them behind the hedges.
But my question to you is that the person who's requesting that these 4 trees be waived is the person who lives in the house where the hedges are. Is that correct?
No, it's the owner of the subdivision. It's the estate of Carmine Sagisi, and this is, who's here tonight, and one of the sons.
Do we have subdivisions that a lot for hedges rather than trees?
No.
Do you mind if,
Not at all.
No, of course not.
go ahead.
Should I say myself?
Yeah.
So, that,
You want to
You have to give
introduce
your name
yourself?
and
I'm
address
sorry.
for the record, please.
Sorry.
my name is Joseph Sajasi. So the estate of my father subdivided that 3 properties and sold that house at 101 that has the hedges on it. The new owners are not in favor of putting trees in there and taking care of them or doing anything.
Well, I think that, in my
house has
opinion,
been sold.
their opinion would be the most important here. They're not here, but if
Well-
the person who lives there,
Doesn't
who's
want-
gonna live there for, from now and forever, or for how long, would rather have the hedges as opposed to the trees.
I don't know.
think that, to me, that person's opinion is very important.
Well, when speaking with them, I think they're indifferent to it. But in a year from now, when they're supposed to take care of these trees, if the trees are not there anymore, then we have to go back in and plant more trees. That's why we requested the waiver. They're not, saying no. They're saying no, it's our property, and they said they're going to end up doing something in the front. So, we don't own it, we can't force them. So we
Well, I'm just saying, as a
That's the
board
estate.
member, we're being asked to waive a condition that was in a approval in the past of them putting in 4 trees. And obviously, we have to do what we think is best for the people who live there and the whole community, but I think that a very important, my just personal opinion, a very important piece of the puzzle is how the people who live there feel.
I think you need more than just a homeowner. You would need the entire neighborhood would have to weigh in on that. Because, I mean, I live in a subdivision where street trees are required.
The more opinions, the better, as far as
Right.
I'm concerned.
But
But I
street trees
I
are
think that,
required.
first and foremost, the people who live there, we should know what they think. And yes, obviously, if there's next door neighbors, everybody should have the right to come and
Right.
say what they think.
So just to elaborate just 1 second. So this has been undergoing 14 years of subdivision. The estate's been open 6 years. We're just trying to close the estate. In order to do that and get off the bond, that's why we put the waiver in as a substitute for the hedges. So using the hedges as a substitution. That's our motivation for the waiver.
Okay,
If I
This
could
was,
make
this
a
was part of a 3-lot subdivision.
Correct.
Where are the other lots in proximity?
Right next to them. One is
And-
my father's house, which is
Okay,
being
and they have
sold.
they have adequate trees?
Yeah, and they've used substitute trees there for the required 8, 2 of them are substituted on that house. And the one next to that is my office, which is further down 25.
Okay.
Those 3 have all been divided. The 101's been sold, 107, which is next door, is in contract, and then there's my office. So that was the motivation to have it waived.
If I could say something, perhaps a suggestion. Street trees are required by the code for the betterment of the whole town, for a whole bunch of reasons, property values, ecology, and so on. And normally, I think the board hasn't waived them unless there are existing trees that match, or would be the same as, the trees that would be planted. In this situation, the intent was to plant them where the hedges are. Then, if somebody wanted to keep the hedge, our recommendation is plant them behind the hedge. If the homeowner doesn't want them behind the hedge, my recommendation would be is to take out the portions of the hedge necessary to plant the trees so you could get off the bond.
I can't
At
believe
whose
we're taking
expense,
so
Dave?
much time
The builders.
with such a silly thing.
I don't think it's a silly thing. I do
Well, I
feel
do.
that the
I
street
do.
trees are required. I mean, like I said,
And
I live in a
and
subdivision.
You want us to go to the whole neighborhood and discuss about 4
Well,
street
'cause
trees.
It's a
He's better
subdivision,
off
it's a
planting the
town
trees.
ordinance to have street trees. And I know that I've seen it on one of my blocks where one of the neighbors, they had the street trees there. It was a subdivision that was put in 97. They eliminated all the street trees. A couple of neighbors complained about it and they had to plant
That's
the trees
different.
again.
It's
Does
a
this
different
property
story.
this property, is on 25A?
Yeah.
Is there any sidewalks where people walk
I
by
don't
where those
think there are
hedges are?
sidewalks there.
No.
There are no
So like, in other
sidewalks.
words, the shade issue is not really an issue because people aren't gonna be walking
No.
there that much.
No, and there's, I believe, the reason why the hedges were planted years ago was to give the people who live in the house some sort of privacy from the busy traffic. So now, planning is saying, okay, well, put the trees behind the hedges. To what end?
too close?
Nobody's gonna see them. So who are you, what are you
Well, eventually
beautifying?
you'll see them. When they grow
What?
bigger, eventually you'll see them.
Oh, sure, well, maybe 10, 15 years from now.
Well,
But
question
they-
I have
you'd
is,
see them
is
at the
there
time
enough
of
room?
planting. I mean, they're twice the height of the hedge at the time they go in, so you see them right away. You
The
see
hedge is 12 feet, the street
Oh, I thought you said they were
trees.
7 feet. Didn't earlier
No.
you say it was 7 feet high?
They're about 12.
12, okay, so you see the top
You
2
can look at
feet.
the picture there, you see.
Okay.
Oh, a quick question.
Much higher than the top
is-
of a car.
A quick question is, how much room is there between the hedge and the house? I don't think I want to plant trees right on top of my house, but, that's my personal opinion.
Right.
I try
This-
to keep things a little bit away.
Yeah, we can see the setback is almost double the requirement. The requirement's 40 feet, the house looks like it's 65, 70 maybe. Maybe even 80 to the front wall, 65 to the porch. But, obviously it's up to the board, but I think it's a good rule to have in the subdivision regulations. The board's been pretty consistent requiring them in all subdivisions. And again, it's for the betterment of the public, not the homeowner.
If I could just make an observation, I think you should clarify for the record, I think it's important to have it on the record. Like in 2014, when the final conditional approval was given with the 8 trees, what were the facts on the ground with respect to the sedge versus the trees? I think it's important just to have it factually on the record.
Obviously, the hedge was there.
Okay, so it was understood that at that particular point in 2014, that there were going to be 8 trees plus the hedge.
I don't know if the applicant understood it. I mean, obviously, that was the condition. I don't know what was in the mind
Well,
of
what I
the...
mean is the paperwork that was approved by the board would have included 8 trees plus the hedge.
Well,
Correct.
but right now, we're only talking about planting or not planting 4 trees in the vicinity of where the hedge is, right? That's what we're debating now, correct?
Correct.
Does anybody want to compromise of putting in 2 trees? That way, it's not as much work, but yet we do satisfy planning's goal of having street trees, which we understand that's part of the code. and
Okay,
It's part of the
okay.
code, and
I give up.
we like street trees, we think they serve a lot of purpose, it's in the code for a reason, but I'm just saying, maybe 2 trees wouldn't be as much expense for them, still serve the purpose of having trees there, which is what the code promotes. Just a suggestion.
Maybe one on either side so
Well, they
that
could
you can
put them
still
where they
keep the
think
hedge,
they
I don't know.
Want to put them, I'm not going to tell them where to put them. I'm just
I hate
throwing
to
out
see
as a
that hedge
suggestion.
What about if we give you the money and you plant trees somewhere else? We do that once in a while.
The issue-
Generally, I argue
I
that
think
I'm
the
not going
issue
to
is
do
not
that,
setting
but
the precedent, right, Dave? Isn't that the most important thing, and that's what you're telling us
Well,
also,
the-
Paul?
Yeah, indirectly,
So we
I'm
should
saying that
go
I
with-
think you need to work off of the record. When you folks approved, your predecessors or you voted in 2014.
To put the
you
trees in.
voted on 8 trees with an existing hedge.
So
That's the factual
we should-
predicate, or if you, I don't know how you can get away from that.
We should say uniform on what before us.
We can't change and
Sure we
we don't
can.
have that.
Well, but with a foundation, I mean, what's the foundation? I mean, Dave has just laid the professional, record for why there's the imposition of the 8 trees, and there seemed to be some confusion listening to the conversation that the trees were somehow being substituted for hedges or vice versa. But that's not the case. It was always contemplated hedges plus trees.
But we're talking about, you said 8 trees, right now we're talking about 4 trees, right?
Right. But it was on the other
But-
part of the other
But
parcels,
that's,
right?
but that's not in dispute now.
But it's the record. I mean, these 4 were part of the 8.
Right, but now we're only talking about 4.
Right, they gave us
But
4
we're
when they
different
were
board
supposed to give
members,
us
so we
8.
can
Is that what
change
we're
our
saying?
mind, right?
That's, looking at the record that I see, that's
That's what
appears
you're
to be the
saying.
case.
All right, so they owe us 4 trees. Okay.
But they are here to ask.
They're
We
asking
waiver
us-
it.
They're asking us to waive it
Now, let
for
me
the
just
reasons
get,
that he said.
what is the front property line? How many feet?
what's the,
The frontage?
128?
128, and how long is the hedge? The whole 128?
Minus
Between
the
the two
driveway.
driveways there,
Okay,
probably 120.
so there's no room on either side of the hedge because there's driveways there. I think I recall, passing this and seeing it.
I was going to say, did the board inspect the site on this? I don't know if you want to table it and...
I
a great idea.
drove by, but I
Let's go
didn't
look at
stop,
You wanna
I
see
couldn't
it?
Yeah,
stop
let's
because
go
it's
look at
right
it.
there, but.
I think we always do that. Let's
Yes.
continue doing
If
that.
you don't mind us perusing the
mind?
property.
It's not my property anymore, we sold it.
Do you mind if we just postpone it
It's
till
only gonna be
even?
probably till the next meeting
Yeah,
anyway.
it's
don't
only 2
walk
weeks.
on the property because we don't know what the guy is
We
gonna do.
could just drive by fast in the car.
Especially you, don't you?
That Corvette, that one over there, huh?
That's
It's only
fine.
gonna be 2 weeks.
Yeah, it's
right?
only to the 18th. Let us go look.
No,
just
it's
to
gotta
make a-
be, after that, because I'll be, out of the country. November,
What's
whatever
the
your
first meeting
meeting.
in November?
Yeah,
Our next meeting is
you
the
want
18th
November?
of October, then November 1 and 15th.
does it matter to you? November 15th then.
Really? Okay.
Okay.
Okay,
Okay, you want a motion?
I think that's the
Yeah.
best move.
Motion to table?
Recess first.
Recess the hearing.
Want to
Yeah.
recess the
Not
hearing?
close,
Yes.
recess.
In the matter of number 1089, map of Marie's homestead, I move that we recess the public hearing.
Second.
All those in favor?
Aye.
Opposed? Motion carries. The hearing is recessed until November 15th.
Right, the motion is that we're gonna recess the matter till the November 15th
Yes.
Yeah, I'm gonna
meeting of this board.
I'm gonna
You're
table
correct.
that now, right?
To a date
Yeah.
certain.
Yes, we table.
Yeah, in the matter of number 1089, map of Maria's homestead, I move that we table resolution to the November 15th meeting of the planning board.
All those in favor?
Aye.
Aye.
Opposed? Motion carries. The resolution is tabled till November 15th. This concert evergreens in this concert.
We hope it will be in this concert ever.
You never know.
The applicant has submitted the affidavit of posting for Nest Concert Evergreens. The applicant, just a quick memo. The applicant requests to waive the requirements to install 490 feet of sidewalk, a precast storm pool, and 40 feet of 15-inch storm drain pipe within the subdivision known as number 1049 map of Nest Concert Evergreens. This matter was last heard at the September 13th, 2017 planning board meeting. The matter could not be acted on because the applicant submitted a defective affidavit of posting. The hearing was therefore recessed to the October 4th, 2017 meeting, and the following resolution was tabled. The Planning Department offers the following resolution for the board's consideration. Planning Board Resolution Number blank 2017, waiver request of public improvements for number 1049 map of Nesconset Evergreens. Whereas the Planning Board has considered the request to waive 490 feet of sidewalk, a precast storm pool, and 40 feet of 15-inch storm drain pipe within the subdivision known as number 1049 map of Nesconset Evergreens. Now therefore be it first resolved that the Planning Board hereby approves the request to waive 490 feet of sidewalk, a precast storm pool, and 40 feet of 15-inch storm drain pipe within the subdivision known as number 1049 map of Nesconset Evergreens for the reasons presented in the Planning Department's memorandum dated September 18, 2017, and read into the record at the September 13, 2017 Planning Board meeting.
Good evening, Mr. Chairman, members of the board. John Zoll on behalf of the applicant, and basically hope that the board would adopt the resolution granting the waiver and submit the affidavit posting dated today. Thank you very much.
Any questions from the board? Any members of the public wish to be heard on this matter? There being no question or public comment, is there a motion?
In the matter of number 1049, map of Wisconsin Evergreens, I move that we close the public hearing.
Second.
All those in favor?
Aye.
Opposed? Motion carries. Our hearing's closed.
Thank you very much.
In
On the resolution?
In the matter of number 1049, map of Wisconsin Evergreens, I move that we adopt the resolution as read in accordance with the recommendation of the planning department.
Second.
All those in favor?
Aye.
Opposed? Motion carries. The resolution is adopted. And the next item on the agenda, I understand you're requesting a recess.
Yes, Mr. Chairman, members of the board, this has to do with Law Park. Mr. Tramarka was here, and I had written a letter to Mr. Sabatino. He responded this afternoon. So what I'd like to do is that the board could put this matter over till November 15th, and if I have to prepare, go forward with the hearing and present the case and see how it proceeds. And perhaps between now and then, myself and Mr. Tramarka can come up with some type of resolution. Right now, Mr. Tramarka was here on behalf of the surrounding residents. My understanding is that the residents don't have any particular objection to the fence, but they have an objection to the curb cut, so we cannot get that consent for the curb cut. So I have to deal with that issue. But I also would just like the board to know with respect to the fence, just so you know what Mr. Barnett has gone through. He got a permit for the fence when he applied. Afterwards, the permit was rescinded because he needed to get a variance. The town told him the 20-foot variance, so I applied for 20-foot variance. Thereafter, the residents apparently met with planning and was told, no, measuring it from the wrong spot, it's a 30-foot variance. So I was supposed to amend the application. Then I got a call from building, because I had to go for new denial, and I was told it might not be 30, it might be 20, it might be 10. I'm waiting for Mr. Bill White, the building official, to get back to that to make the determination. So as you can see, the frustration on all levels of this application. Now, when you have a planning board, the planning department recommends relief for these covenants, I have neighbors who we've had a disagreement and upset on both sides. So what we'll do is we'll go to the meeting, for the hearing for November 15th. I'll present the case, and Mr. Tramarko will oppose it, I imagine, but between now and then, maybe we can have some type of consensus that would work for everybody. But thank you for listening to me, and I appreciate it.
Okay, good luck.
If November 15th is good for the board and Mr. Tramarko?
Thank you, Mrs. Zola.
I wasn't concerned about you.
Okay, so.
The people that are sitting here are people that live on Laura Court and would like to be heard tonight. The case has been adjourned 3 times already with no resolution from the board. The board could act tonight if they wanted to and either grant or deny. I believe the application is to
Okay, did we-
amend those covenants.
But we don't have a resolution in front of us. I don't see one that was prepared, because I think in anticipation of the matter being adjourned, I don't see a resolution, proposed resolution, either granting or denying it. So unless we're gonna do one on the
The
fly,
Well, the proposed resolution would come from the planning department, which I guess, they haven't taken a position on it. Well, they have, as a matter of fact, with their recommendation.
No, we don't have.
well, I'm just saying that we have a packet here with the agenda and all, and the recommendations on each of the various
Yeah,
matters, and on my
there's no-
packet,
there's no
unless it's missing
bill.
something, I don't see any recommendation on this application one way or the other, or a proposed resolution one way or the other. So, as I said, unless we're gonna prepare the resolution on the fly, I don't think we are in a position to vote on it. But if people wanna be heard, that's a different issue.
Well, they do.
No, they
Well,
should.
the public hearing is open, and we certainly,
Okay.
you know,
Yeah, definitely.
welcome their comments.
So,
But again, you requested a,
It's just, this is troubling to me, and Mr. Tramarko, you on more occasion requested adjournments. I have requested adjournment, actually, Matt had called my office asking if I was gonna request adjournment, because I wanted to deal with this one issue with Mr. Sabatino. I requested adjournment out of respect for the process, out of respect for my client. Putting it over November 15th is no prejudice to anybody. I'd like to have the photos that I have. I'm not prepared to present to you what I believe are reasons why. And if Mr. Tramarko wants, you did prepare a resolution the first night to adopt it, to approve all the waiver of those covenants and changing it. And then I was told the day before the hearing that because of that unanimous consent requirement that's in that covenant, it couldn't be done. And we hoped that we could sit down with neighbors, which has not been fruitful or successful. So out of respect for all of us here, the November 15th date, I'll have my evidence to present, I'll have witnesses here, put forward, and to have people here talk about why they don't want this, I think is just kind of counterproductive. Do it all one night, at one hearing, give everyone an opportunity to be heard fairly, and get the whole case all at once.
Well, Mr. Zoll, I don't think anybody is going to deny you the right to make your case. If you want time to make that case on November 15th, to me personally, that's fine. Obviously, the other board members will tell you how they feel. But I think what Mr. Tramarko was saying is that these residents came down here tonight expecting to be heard on this matter. And I don't personally see how it disadvantages you to have them speak tonight as opposed to on November 15th. As a matter of fact, it might even
As
be
long
an
as I have my
advantage.
opportunity on November 15th at the board.
Of course.
That's fine, thank you.
Yeah, we're not foreclosing your right
Thank
to
you.
make
Or
your
voting on it
case or
tonight.
voting on it either.
Okay.
You have the full right to make your case and bring whatever evidence you want. But I think what Mr. Tramarko is saying is that we have some residents here who came down here expecting to be heard on it, and they may not want to be inconvenienced to come back again. So what's the harm in letting them speak now?
Also, just so you know, I did contact Mr. Tramarko and let him know I was gonna be requesting adjournment, so, but that's fine.
he did, and I contacted and I told my clients, but they want to be heard.
So they should, they're residents
They
of the
want
town,
if
they
they'd
should.
rather be heard
and you
tonight
can
rather than
address
come
their
back in
concerns
November.
in your presentation at a later time.
I think
And
it's
I
an
appreciate
advantage.
that was my biggest
Yeah,
concern,
I
thank
think
you.
it's an advantage to them, not a disadvantage.
Let them talk.
Yeah.
So,
Okay,
Anyone wish to be heard, please come forward, state your name and address for the record.
Address everything that they say, prepare for it, right?
My name is Fred Glock, my wife Sherry. Last name is spelled Glock. We reside at 19 Laura Court in Wisconsin. We are Lot 1 on the plat map of Laura Park. Also, we have the other homeowners that live in the court. There are 2 other homeowners in that court, 20 Laura Court and 21 Laura Court. They were also present. So I really don't see a need for a recess for this meeting because we're all here. I have a letter I wrote to the town board I'd like to present. It has attachments and it has before and after photos. I'd like to present it and I'd like to read the letter into the minutes.
Go ahead. Give it to me.
I see the photos.
The photos are on the back. We and Fred and Sherry Glock are the original owners of 19 Laura Court in Wisconsin. We've been there for 25 years. After attending the planning board meeting on August 16, 2017, we received a message from Mr. Zolo on the following Thursday, August 24th. He spoke with our neighbor, Jim and Donna Monet. Mr. Zolo said he was not able to meet with us before Wednesday, September 6th. We contacted his office explaining that we did not want to meet so close to the recess date of September 13th. His secretary was going to accommodate us on Monday, August 28th, until she called back and said Mr. Zola was too busy. At that time, we, along with Jim and Donna Monet, who reside at 21 Laura Court, known as Lot 2, decided to move forward to hire an attorney, Mr. Vincent Chamarco, to represent us so we did not have to continue this back and forth with Mr. Zolo. As the planning board recommended at the last meeting, he recommended that we try to sit down and negotiate an agreement with Mr. Zolo. We spoke with the Monets and agreed that we'd be willing to allow Mr. Barnett to keep his fence where it is, thereby increasing his usable rear yard by a substantial amount. We would agree if Mr. Barnett agreed to landscape and maintain the property on Laura Court, in addition to replacing the trees he improperly had removed and was fined for, which would give us back some of our natural sound and visual barrier of the Great Hollow Middle School entrance and his rear yard. We felt this was fair as the covenant does not allow for it, and we do not have to agree to any changes. We are all steadfast against Mr. Barnett retaining the driveway he installed, as we are concerned about the roadway he established from Southern Boulevard through to Laura Court. There is no reason why Mr. Barnett needs access into Laura Court. A large gate and driveway opening will only bring additional vehicles into our court, which is our number one concern. Mr. Chamarco contacted Mr. Zolo to relay our decision to try to remediate the situation. Mr. Zolo represented that he was going to attempt to overturn our covenant. The fact that Mr. Barnett will not even try to negotiate an agreement with us is disappointing, to say the least. We did not have to negotiate at all. We're back to where we started from, and now had to spend money to hire an attorney. Due to the improper issuance of permits by the town of Smithtown, for over a year, we have endured unnecessary emotional stress, aggravation, and had to devote much of our time to having the covenant retrieved and persisted to have it upheld, as we are still trying to do today. The tree removal, fence, and driveway installation affecting our court should never have taken place. We have lost our privacy as well as our natural sound and visual barrier to the Great Hollow Middle School entrance, Southern Boulevard, and Mr. Barnett's property. Previously, we had no view of the school entrance, Southern Boulevard, or Mr. Barnett's property. We believe this has negatively affected the resale value of our home. The covenant has obviously created to protect us from this happening, and we had our home built with the reassurance that the property of 148 Southern Boulevard could not access lower court. For the covenant to be negated, we feel would put us in a position to file an Article 78 against the town of Smithtown. We expect the town of Smithtown and the planning board to stand behind our rights as stated in our covenant. Thank you.
Can I ask if
Just
we're able
introduce,
to...
put
Oh,
your name in.
yes, I'm Sherry Glock, Fred's wife.
There you go.
I just wanted to ask if at your last meeting you had said you were going to go and view the property? Did anybody get to go by and take a look at it when we were here last?
Yes.
The one where it goes right through. Yeah.
Okay, I was just curious if anybody, if you saw it, and now you can see the before pictures of what was there previously. So, it's a tremendous change in what's happened to our environment, to say the least. Donna, did you want to say anything? Tony, did you want to speak at all? Yeah, I think that, we're submitting that, so, yeah. Okay.
Good evening. For the record, legal name is Antonio Wong. I go by the name Tony. I am the new property owner of 20 Laura Court as of August 18th. I have been informed about the situation on the property with Mr. Burnett, and I think the board mentioned tonight about the fact that a resolution has not been offered on the proposal. So, given the information is being presented today, in my view, what would convince the board or convince Mr. Zolo to present on November 15th, if we adjourn this proposal until November 15th, to actually resolve the matter at that point. I see that this matter has been going for a while, and so not only to save the time of my people who are also living on the court, my own time as well, is to have an understanding when this resolution will be provided, and we can then resolve this issue.
Okay, I think we're letting both parties try to work this out. If they fail or are unable to do so, then I imagine the board will have to act on the measure. But again, Mr. Zolo has expressed a desire to meet with the residents and to work this issue out, and we're going to give him that opportunity.
And I believe that's fine. That's a very good idea. I think what I'd like to see is somehow to incentivize Mr. Zolo and Mr. Burnett to come up with a proposal, and if needed, to negotiate with have a session where we can discuss
I think that's what he wants to do.
So, in the sense that then I think the agreement is that, what I'd like to see is something where we go tonight, and if we have to postpone this until November 15th, that we will reach some sort of resolution on November 15th. From what I've seen online, that this issue was supposed to be discussed in the past. It has been adjourned and postponed at least a couple times, including tonight.
Tonight,
So-
it's not being adjourned or postponed. We're just giving you the opportunity to speak as a courtesy. So Mr. Zolo's been trying to do this for 2 months now. So I think the board has been trying every which way to try to get this resolved amongst yourselves.
Yes,
Mr.
but
Zolo is the applicant, and he's
Yes.
asked us for time to make his presentation. For whatever reason, says he wants more time to make his presentation. That's not going to be made tonight. And also, in the interim, perhaps meet with you to see if possibly something could be resolved. That's what we're going to give him a chance to do. And then
Okay.
if it can be resolved, great. If it can't be resolved, then we'll have to make a decision on the merits.
Okay, I should also point out that one of the very reasons that I moved to lower court is because it is a court, it's a cul-de-sac, it's a closed street. I have two small kids, and I would prefer to keep the traffic to a minimum. So that is my primary concern for this, for the property I purchased.
Okay.
Thank you.
Wish- Anyone else wish to be heard, please come forward.
That's all right.
Donna Manay, I'm 21 Laura Court. M-I-N-E-T. Okay. I wasn't going to speak tonight, but I have to say I've been a little frustrated. I know my husband has spoken a couple of times. My husband was going to meet with Mr. Zolo, but then we basically made an offer to Mr. Zolo and Mr. Barnett, which we thought was pretty fair, to keep the fence, because we don't want to take away his property. He deserves his property if that's, you know, when we found out that part of the cul-de-sac where the trees was his backyard, we don't want to take that away from him. We really don't, because if it was me, I'd want my bigger backyard too. When everything was happening, we were telling Mr. Zolo and everybody that there was a covenant restrictions, that you got to slow down, you got to look at what's going on, and nobody listened to us. So now here we are. We did make the offer. I think we tried to just take care of this by giving Mr. Barnett the fence. I don't understand why he needs this driveway so badly on our court. It goes right from Southern Boulevard, right to our street. My house and Sherry and Fred, we're up higher, so I don't know if you came to Laura Court to see. People now from Southern Boulevard can see my house. I've lost all privacy. The sound barrier, the pollution with the buses coming through on Great Hollow. It was, you know, we had tons of trees. I'm a big environmentalist, so that broke my heart when all the trees were coming down. So I don't understand what's left if we're willing to make the fence offer, which I think is really fair. And I think it was the right thing to do. I mean, Mr. Barnett just moved in a year ago. They've been living there 25 years. I've been living there a decade. It feels like we're trying to reach out and do the right thing, and the driveway is the problem, and I don't understand even why he needs this driveway so badly. That's very honestly. And it does create more traffic, and I have two girls too. One of them likes to ride their bicycle going around the cul-de-sac. They're not allowed to go on the street because it's just too busy to ride a bicycle on the street. So they've ridden back and forth on the cul-de-sac. They can be driving back and out from Southern Boulevard onto Laura Court. The kids are not going to know that a car is coming down from Southern Boulevard to Laura Court, because it shouldn't be. And then we don't know if they're going to be parking on the street, coming down Laura Court to come this way. I think it creates more of a dangerous situation to our kids. One of the reasons we bought on a cul-de-sac was for the same reason. We had little kids, and it was safe for them to play there. We played in the street, we played soccer. They learned how to ride their bicycle on that cul-de-sac, knowing that it was only us who came down there, the Glucks, and now the new owners. So it's frustrating that we're putting this off, saying that we're not trying to do the right thing. I think we are trying to do the right thing. I'd like to see Mr. Barnett meet us halfway, and I think giving them the fence, according to the covenant restrictions where it says we all have to agree, I thought that was really fair. And I thought this was really just going to be done, to be very honest, and they would accept the fence, do what he has to do with the trees, and it would be over. And I don't understand, frankly, why this driveway is becoming such an issue for this man. He doesn't live on Laura Court, and I don't think he should have a driveway in front of my house. And, sorry, I was nervous, but that's why I had to say.
Excuse me, I just have a question. What extent the traffic is emanating from this driveway? I mean,
Well, it's been closed off right now, so we
Okay.
don't know what kind of traffic is going to, come from the driveway. But I'm assuming he's going to be coming this way, around, and I guess he's got a tremendous driveway now, so we don't know how it's going to be affected, but I do know that I don't want another driveway on Laura Court, and like I said, because he's going to be coming from Southern Boulevard, he may be backing out this way. You know, the kids are riding their bicycles, they're looking down from this way. They're not looking for someone backing out, and I just think that alone is also a dangerous situation. And again, I'm just not sure, he bought a house on Southern Boulevard, why now he should have access to our cul-de-sac and our court. I just don't understand that. And I thought we were being really fair and trying to compromise. And we did reach out to Mr. Zola and tell him, we're willing to compromise on the fence. He could have the fence. We don't want to take his property away from him. He wants to have a bigger backyard. I understand that. I'd want a bigger backyard too. But the driveway is really a point for us that we just don't want to give on. And I don't understand why we can't compromise, and I thought we were being very fair. I really did.
Was there a permit issued for the curb cut? No.
It was, from what I understand, there was a permit issued, and then Mr. Murphy realized there was covenant restrictions, and he sent him a letter and went down there and told him to stop. And then even after he was told to stop, and the letter was issued, he put down pavers. So I think a lot of the things that Mr. Barnett did was partially on his own doing.
Self-inflicted.
So,
All right, thank you.
okay, thank you.
There's just one other point I'd like to... Yes, Fred Glock, 19 Lower Court. Just one other point I'd like to bring up is that I'm the original owner. I've been there for over 25 years. The Manets are there over 10 years. Mr. Barnett is there 18 months, if that. I don't even think it's 18 months. He came in and he turned our court upside down. And now he wants to overturn our covenant that, you know, we enjoyed for the past 25 years.
All right, thank you. Anyone else, please come forward.
Glenn Forbes, 5 Lower Court. I've been living on Lower Court since 1985. At that time, it came where the development was built at the end of the court, and I knew there was a covenant in place. On that day when Mr. Barnett had gone down there with landscapers, which was multiple trucks, it was really an assault on the wooded area that I think you've seen pictures on. I had gone down there, Donna was out there, because she was upset. I believe it was a Sunday morning, and they were there very early. But I got down there, and he played himself off as the landscaper, not as the owner of the property. When I told him to please hold on, because I had called the town and the police department, he said he was paying his men, so he continued. There was the most amount of people that I've ever seen go up trees with this speed and intent to destroy that wooded area, even though I had asked him to postpone that the police and I think public safety came were en route. He just continued to cut down the trees. Some of the concerns that I have is on the north side of his fence. I think it's like 3 feet tall, and he has a pool, and nobody's addressed it. Going underneath the fence for the wide gate, it's not self-closing, and easily a child could go underneath there and fall into the pool. So I would just ask if there's people to contact. I have, and I've gotten nobody who's moved forward for that. Thank you.
Anyone else wish to be
You can
heard?
come back up. You did so good the first time. Yeah, you go.
Donna Monet again. And speaking of the pool, you know, from my house, I could see his pool. And he's right, there's a 4-foot fence on the side of your house, Mr. Wong's house. So nothing is to code for his built-in pool. Nothing. And again, I think that's a liability for the town too, because if that hasn't been addressed, I mean, insurance, so. If that hasn't been addressed and God forbid something did happen.
And you call public safety?
Yeah, and, you know, this was from last year, we've talked about all of this too, you know, so just to add that to the record. Okay, thank you.
Anyone else?
Good man, Dave.
I thought Dave was going to speak.
Yeah, it's
All right, I'll get up. I'm Colleen Forbes, 5 Laura Court. I've lived there for just about 40 years on Laura Court. I'm not part of the covenant, but I am well aware of the covenant. I was aware of the covenant when it was put in place. When they put that subdivision in, I was in the, you know, I was there. I heard it. I knew about it. He was told that day there was a covenant in place. We know he was there at the property site, didn't say he was the homeowner at the time, was spoken to. You know, we had that covenant was an issue one time before.
that was brought up to the town when some other trees were removed and there was a large amount of flooding, probably 15 years ago or so. So, you know, just letting you know that I'm concerned about the pool as well. You know, and I think it's an alley is what he's created. You're worried about a subdivision with the block, you know, and somebody's, you know, that you just spoke about, you know, how it's an alleyway. I mean, I just think you have to look at the safety of the property and really that fence was 40 feet up, because that's where the original owners, the McGee's, I think it was, that owned the property before from Southern Boulevard. That built-in pool was fenced, further up separately, you know? And when they took that fence down, you're talking about a big safety concern. You have middle schoolers who are going to that school, walking down that property. You know, that's an accident waiting to happen. The gate is not self-closing on that driveway. And I believe that fence is too short. Now it's a frontage. If you're gonna call it two frontages, now what? So that's my concern.
Thank you.
Thank you.
Anyone else wish to be heard? There being no further public comment, is there a motion to recess this to?
I just want to say one thing.
November
Yes.
15th?
Just so we're clear, at the next meeting, Mr. Zolo is going to make his case for modification, removal.
As of now, that's what the plan is.
Well, that's what I think John said, and that's fine. But hopefully there'll be finality to at least what he's going to put in on that date and what I'm going to put in. John did give me a copy of the letter he sent to your council with respect to a couple of cases that he cited, and I suspect he'll copy me with anything he sends Mr. Sabatino. And we'll all be ready on the 15th.
Well, I just have just one question and perhaps one comment, and you may be ready addressing this with Mr. Sabatino or not. What we're speaking about here is the Declaration of Covenants and Restrictions dated February 27th, 1992. That's in our packet. Is that correct, Mr. Flynn? Is that the covenants that we're talking about here? It's in the packet? Okay.
Let's see.
Covenant of
We're talking about, people have been talking about covenants, and trying to make sure that, for the record, that we're clear about which covenants that we're talking about. And in our packet is a document, 2-page document, actually with the notarizing
I just had the file out
acknowledgements, it's 3
before.
pages. It says Declaration of Covenants and Restrictions dated February 27th, 1992. I just want to make sure, is that the covenants that everybody's talking about here?
If you could just give us a minute, please.
Sure.
This was the letter handed to us with several attachments, and the covenants and the photos before and after are part
Is
of it.
that the covenants are, I'm just making sure that the covenants that we're talking about are the covenants that's attached to the letter.
Yes.
That, if you'd like me to embellish, that's the covenant, which everybody, well, I don't know if they looked at it, but when you buy the property, that covenant is part of the title report. And there was also a performance bond estimate with a resolution by the town, which indicates that a covenant will be drawn by the then applicants, which I think were the subdividers. But that's the right
Well,
covenant.
thank you. Now,
February 27th.
it was just,
Yep.
that was my question. Now, the comment, we have associated with this application, Mr. Tramarko, we have Mr. Zolo, 2 attorneys, very well versed in the law surrounding land use. And I have a question here, and this has nothing to do with the merits of the covenant as to whether or not it's good, bad, or otherwise. But item number 4 in this covenant that we just identified says, the within covenants and restrictions may be amended, annulled, altered, or repealed at any time upon the consent of the then owners of the premises and the planning board of the town of Smithtown after public hearing. Okay? My question is, and maybe this can be addressed by someone at November 15th, or maybe not, does this covenant constitute, is it enforceable or not, and does it constitute a delegation of a governmental function to private citizens. We've
That's
had
the
that issue in
argument.
the
Yep,
past, and
that's
that's
the
something that
question.
perhaps somebody could address between now and November 15th, because that, I think, is a legal issue that we're all looking at here.
Right.
Now, again, not to the merits of the
No,
covenant,
I know
but
what you're saying.
but
Just the covenants.
whether or not this can properly whether it constitutes a delegation of a governmental function to private citizens, I think that should be addressed.
That's it in a nutshell.
That's the issue.
That's an issue.
Can I just get Mr. Schmarko finished?
You want to come here and talk?
Thank you for your patience. I just want to be able to, I would like all the copies of minutes from today's discussion that was on the record here. Also, I'd like to get a copy of what was presented to the board, including the photos. And more importantly, I listened to what the neighbors had to say. I will speak to my client. I do need some time to sit down with him. And most importantly, I want everyone to know I was not part of this when it started. I was brought in after everything else was done. I had nothing to do with anything. So I don't want to take any blame for whatever Mr. Barnett did. I wasn't party to it. All I know is, from Mr. Barnett's point of view, he got a building permit for the fence. They took it back. It was suggested to him get a curb cut permit. He got a curb cut permit. It was taken back. He had a tree person come and tell me he could take down the trees. He thought he could. So whatever happened, a set of unfortunate circumstances, I think I will talk to Mr. Barnett. Maybe we can have a resolution before the 15th. I will try. And yes, I tried to schedule appointments, but I'm a sole practitioner, and that happened to be the time of Labor Day weekend. I actually took some time off, so I'm sorry about that. I did apologize. No, but I'm sorry because I don't want people to think I'm putting them off, but these things happen. So, and sometimes people get the wrong impression, so I'm sorry about that. I understand neighbors' concerns. I don't take it lightly. And the thing about the issue they talked about, the pool, if it's CO'd, it's CO'd. If it's not, there's issues that have to be taken care of. That's something then, and Mr. Flynn did the right thing, contact public safety or building and let them take a look at it. If it has to be, something has to be taken care of, it should be. All these issues are serious issues, and I appreciate everyone's patience, and thank you so much for putting this over for November 15th, but we will try to have a resolution before that date. Thank you.
And just for the record, since Mr. Zola made reference to it, what we've been handed is a letter dated October 4th, 2017. On the top, it says Fred and Sherry Glock. It gives their address. It's a two-page letter. Attached to that appears to be a copy of a resolution dated September 4th, 1991. Then attached to that also is the covenants and restrictions dated February 27th, 1992, which we've spoken about. There's also a letter on the stationery of the Highway Department dated August 17, 2016, signed by Robert Murphy, Superintendent of Highways. Or it's a copy of the letter, and then there's several pages of photographs which the residents have been describing. So if that's what you want to get access to, I'm sure if you contact
Sure I
the
will.
planning staff, they'll be able to give you a copy of it.
Thank you very much.
Okay.
Thank you.
Is there anything else? Motion?
Oh, we got minutes, right? Is there minutes?
No, we have to do this
we
one
have to-
first.
We have to recess.
In the matter of number 818, map of Laura Park, I move that we recess the public hearing to the November 15th, 2017 meeting of the planning board.
Second.
All those in favor?
Aye.
Opposed? Motion carries. We recessed until November 15th.
Thank you. Good night.
Good night. The next item on the agenda is a final subdivision map of open meadow in Fort Salonga.
That's here? I don't.
That's-
I don't see that.
That's going to be recessed also.
Yes, and we're recessing this.
You have nothing in the packet?
I have nothing in the packet. Mr. Tramarko will lead us forward and tell us what he desires.
Well,
The
we
board's action
are
to be.
working with the surveyor to modify the map that we put in, and if you remember, Matt Colato indicated that we really weren't changing it the first time we put it in. Surveyors are a rare breed, and they take the time that they want to take. And so if you could do November 15th,
November 15th seems to be the day.
thank you.
It's gonna
Okay.
be a busy night.
You want a motion again?
Yes.
Okay. In the matter of number 1156, map of open meadow, I move that we recess the public hearing to the November 15th, 2017 meeting of the Planning Board.
Second.
All those in favor?
Aye.
Opposed? Motion carries. The matter is recessed. And under other matters, we have the adoption of minutes of the May 4th, 2016 and June 4th, 2017.
I move that we adopt the minutes of the May 4th, 2016 and June 14th, 2017 meetings of this board.
Second.
All those in favor?
Aye.
Opposed? Motion carries. The minutes are adopted. There being no further business before the board this evening, we have a motion to adjourn.
Motion to adjourn.
Second.
All those in favor?
Aye.
The board stands adjourned.